of dimensions of sentencing. And without any further delay, I welcome Senior Advocate Hariharan sir.
Good evening, everybody. That was some kind of an introduction. I never thought I would have such a long introduction in any case. I'm just making a correction. I added 2 more years in between. It's 35 years now, though I felt young. Now, coming to the topic, sentencing. Now, this is one topic which most of us defense lawyers don't want to enter into. We would like our trials to finish with an acquittal than to go further. And that is why I feel that this is a topic which has been less explored, because most of us do not devote time to this, considering the fact that once a conviction happens, we also go with this psychology that the client is also going to walk away from us. In fact, if the client is with me and I suffer a conviction, I will go with this psychology that he will probably go to Niazi or he will go to Kamal Nijavan out there, sitting out there. So then why bother? So that psychology of ours prevents us from devoting enough time to this aspect, and a very important aspect, according to me, in relation to a criminal trial. To begin with, in fact, sentencing becomes more important when we talk about cases in the nature of a life sentence or of capital punishment, where it assumes greater significance, though it has significance in other areas as well. So to begin with, I will start with a brief idea in terms of a capital sentence, move on from the capital sentence to the development of law there to a little aspect. I will briefly deal with these aspects because this is a very huge topic otherwise. So to touch every aspect of it may be a little difficult in a compressed lecture like this, but I will try nonetheless. So to begin with, in fact, why did I choose this topic is also interesting, because there are 2 films which set my mind thinking. One was a very old film which I think some of the older ones in the audience would recognize. It was a film called Do Aankh Bara Haath. Eh Malik Tere Bande Hum. And there was this famous song which was sung by Lata Mangeshkar there. So this Do Aankh Bara Haath was actually an experiment which was carried out in terms of an open prison. In the sense that here, convicts who had undertaken a reform, who showed characters of reform, were sent to an open prison where they could interact with their families as well, and at the same time earn their living. So this Do Aankh Bara Haath was not a film which was conceived by V. Shantaram as a figment of imagination. This Do Aankh Bara Haath, in fact, originated from an experiment from the state of Ondh, which now exists in Sangli at Maharashtra. So this experiment was carried out in that princely state way back in 1939, which laid that basis of that film. The other film which was interesting in terms of somewhat more relevant in today's times was a film in which Rajesh Khanna acted called Dushman. I don't know how many of you have seen that. In that, a truck driver, while driving on the road, drunk and delayed, decides to drive fast, and a farmer comes beneath the wheels. So it was a very peculiar kind of a sentence which was given, wherein he was told to serve a life term bringing up the family of the man who was deceased. So it was the kind of interaction which was there between the victim and the accused which formed the basis of that story. So these 2 films to a certain extent also brought me thinking that, sentencing should be an important aspect which is not as much discussed in legal forums the way it should be. So coming back to the death penalty, when I talk about the death penalty or the capital sentence, you all know in relation to a murder case there can be only 2 sentences. One, that of life, and the other, that of death, in the alternative. Now this has also got a very interesting history to it. There are two aspects to it. One is the legislative part, and the other is the judicial part. Now, when we talk in terms of the legislative part, 1898, when the code was there, the fundamental rule was that in case of a murder, the sentence which would be accorded by default would be a death sentence. And in case a life sentence was to be given, special reasons had to be written. So you just see where we started, the point where we started, and where we are today. That is why I started with the legislative part of this. Then in 1955 came the first amendment to the code. The 1955 amendment brought it to a different kind of a dimension, that it did away with the reasons to be recorded as far as giving a life sentence is concerned. So which meant that the judgment could go either way. There was no legislative preference towards death, but at the same time, there was no preference towards a life sentence. So that was the position in 1955. Subsequent to that came a very important provision in the Code of Criminal Procedure, and that was 354 clause 3. This got legislated in 1973. Now, what was this distinction? The interesting part was that when we read 353 clause 3 of CRPC, it makes a distinction that special reasons have to be assigned when a death sentence is being accorded. Otherwise, the default sentence in a murder trial will invariably be a life sentence. So from 1898, the journey culminated in 1973 legislatively with a preference, a legislative preference for a life imprisonment. Now, when we look at the judicial approach, now this was the legislative approach. Now, when we look at the judicial approach of the Supreme Court in this matter, the first judgment which comes to my mind, where the death penalty itself was challenged, there was a constitutional challenge that we don't need a death penalty in a society like ours, and death penalty needs to be struck down. This challenge came in a judgment by the name of Jagmohan Singh versus State of Punjab, where the validity of the death sentence was challenged. And this validity of awarding a death sentence, whether you would had the discretion to award one, the Honorable Supreme Court held that in this, as far as validity is concerned, it was perfectly valid to accord a death sentence, so long as judicial discretion, they said that judicial discretion which is used in either according a death sentence or otherwise, as far as this is concerned, they said that judicial discretion is essentially the basis for or a ground against arbitrariness. Because one of the grounds of challenge was that this is an arbitrary kind of a sentence, and therefore it needs to be struck down. So the aspect of arbitrariness was basically combated by the Supreme Court at that point of time by saying that judicial discretion is there, and judicial discretion is essentially the best guarantee against arbitrariness. Now, most of us would laugh on that proposition, but we know how judicial discretion is generally used. So post Jagmohan Singh came a very interesting development by way of a judgment called Ediga versus State of Andhra Pradesh. Ediga Annamma versus State of Andhra Pradesh. This came in 1974, if I am not mistaken. Yes, 1974. Now, as far as this judgment was concerned, this judgment started bringing in the divide, because Justice Krishna Iyer penned this judgment. And in this, Justice Krishna Iyer lamented the lack of judicial guidelines as far as sentencing is concerned. And here, he also said that there needs to be a stress from the point of view of the victim, not only on the point of view of the victim, from the point of view of the accused. What he said was that there was need to factor in the social factors and the personal aspects of the accused while giving a sentence. It was not enough that there was a social outcry. It was also to be seen that what was the milieu in which that crime was committed. So he raised this situation for the first time in this case. And then subsequently, post this, we move on from here to another judgment by the name Rajinder Prasad versus State of UP, which was a 3-judge bench judgment, again authored by Justice Krishna Iyer. wherein he spoke about special reasons, which I said, the special reasons which were mentioned, in order to give a death sentence. He started basically moving the entire jurisprudence in relation to that towards personal, social, physical, and psychological aspects in relation to the accused. So this shift which happened at this point of time was very material, because thereon came the next constitutional challenge, which is now one of the most important judgments that we have in this field, which has seen a shift in terms of jurisprudence as far as death penalty is concerned. And that judgment is a constitutional judgment by the name of Bachchan Singh. Post this came Bachchan Singh. Now, what did Bachchan Singh do? Bachchan Singh dealt with all these judgments, though it upheld the discretion of a court to award a death sentence, but at the same time, it brought in a sentencing policy. Now, this sentencing policy, which Bachchan Singh brought in, was based on two things. One, aggravating circumstances, and the balance of aggravating circumstances to mitigating circumstances. So what would aggravating circumstances mean, or what would mitigating circumstances broadly mean? For instance, during the course of an argument in terms of a sentence, when we normally argue, we try to bring the focus of the court in relation to the aggravating circumstance if we are on the prosecution's end, by saying that there is a past history to the person. There is previous conviction of a similar sort of crime, right? The dastardly nature of the crime. For instance, if we take the case of, say, one of the matters which I did post-conviction, that was of this very famous murder case which happened here in that hotel close by called the Tandoor Kand. Now, Tandoor Kand is a classic example where every time the aggravating circumstance would come to the fore, that what he did post the murder, he put his wife inside the oven and baked her. Now, this was projected as an aggravating serious circumstance wherein the person, they said, was not entitled. There, of course, those aggravating and mitigating circumstances were used post the death sentence being commuted to life. But here, this particular aspect of placing the woman's body inside the bake oven was considered to be one of the severest circumstances, both at the time when the sentence was awarded, wherein no remission was granted, and a life sentence was set to continue for life. I, of course, came much later thereafter when I tried to bring it in within the aspects of remission. So that was one of the major aggravating circumstances which was held against the accused Sushil Sharma at that point of time. Though he managed to escape a death sentence on this basis, which now will basically be an example for the mitigating circumstance. So what was argued as a mitigating circumstance? The fact that when the body of his wife was being removed, there was a noting which was made by the police in the inquest report that the man broke down. He started weeping desperately. The marriage otherwise was a love marriage. There was an allegation that there was an affair which was being carried out by the wife, which essentially impelled him to murder her. The placing of her body in the bakery, essentially the Supreme Court said that it only attracted 211. The woman was already dead by the time the murder had happened. So this aspect, where the Supreme Court noted a very small thing in the inquest report, where there was a finding by the investigating officer that the man broke down when he saw the body of his wife being brought out in charred form, that the Supreme Court said is a mitigating circumstance which shows that there was remorse. So this is one of the factors which the Supreme Court or any other court considers, that whether the man essentially exhibited remorse at that point of time. You commit an offense, there are various reasons why an offense is committed. But then post the commission of the offense, what the conduct of the accused is becomes relevant. So this is an example of a mitigating circumstance. So what did Bachchan Singh do? Bachchan Singh, because you cannot spell out all the circumstances in a watertight compartment. But yes, what Bachchan Singh did was that it created a balance. It gave the defense an opportunity to bring to fore the mitigating circumstances. The aggravating circumstances are always brought to fore by the prosecution because they yell on the top of their head that the crime is dastardly, the person is beyond correction, and we have to send a message to the society. So these kind of arguments are generally raised by the prosecution. So what Bachchan Singh did, Bachchan Singh gave defense a place to stand. It gave a place to stand by way of bringing in these mitigating factors, where the social milieu from which an accused comes also is a relevant circumstance, a mitigating circumstance. What propelled him to do that crime? What was his psychological state at that point of time? Why he was driven to that particular situation? What was his economic condition? And what is the amount of incarceration that he has spent on the death row? Because invariably what happens is that sentences are passed by the Sessions Court, subject to confirmation by the Supreme High Court. It takes its own time. By the time it travels to the Supreme Court till the last stage, the man spends a considerable amount of time on the death row. Now that time that he spends on the death row also becomes a factor which is a mitigating circumstance. So that mitigating circumstance also comes to the fore. So Bachchan Singh did this. Bachchan Singh did also another thing. The most important thing that, according to me, what Bachchan Singh did was, this judgment said that aggravating circumstances, the degree of aggravating circumstances should be of an extreme nature. Whereas it also said that mitigating circumstances should be given a liberal construction. So, in this particular shift which happened in Bachchan Singh from the time of Jagmohan Singh's times and the judgments which came in between was this, that the Supreme Court, the judicial aspect which I am talking about, more or less saw a consonance with the legislative progress which I had spoken of from 1898 to 1973. It became more in consonance with 354 clause 3. Of course, sentencing, one, involves a lot of discretion as far as judges are concerned. Judicial intervention and innovation to a great extent also has done a balancing situation. In fact, today in the afternoon, there was a question which was put to me by Mr. Niazi, who's right here, who's getting bored by what I am saying, probably getting tired by the day. All of you are tired. So he spoke about the Hariharan case. Now the Hariharan case also show a kind of a judicial shift in the thought process, which came much later after Bachchan Singh, because that is one aspect which I wanted to deal. Because Bachchan Singh being the benchmark, being a constitutional bench judgment, according to me, over a period of time has got watered down by the Supreme Court itself in the confused interpretations which the Supreme Court has given. Because Bachchan Singh was then thereafter followed by Machi Singh. Now, Machi Singh was a drastic judgment. It was a judgment which ignored the principles of Bachchan Singh. What did Machi Singh do? Machi Singh brought in the concept of collective conscience. Now, what is collective conscience? Collective conscience means the way we collectively bay for the blood of anybody the police arrests. Every day there is a tirade in the newspaper, supposing the offense is drastic. I am not detracting the dastardliness of the crime. I am not into that aspect. Let us take a simple example. Supposing there is a crime which is committed to the magnitude of, say, Nirbhaya, because Nirbhaya also brought a shift in sentencing. What did Nirbhaya do? Nirbhaya, in a way, basically resulted more in a media trial than anything else. Now, this media trial, which happens not only in Nirbhaya, but in other cases also. Many cases, for instance, let us say, cases which are going on, ED matters which happen every day, gets reported in the newspapers, happenings which happen in court. I do not see why no law is in place that what is being done in court, if at all you need to report only what is actually passed as an order in court. Beyond that, arguments which are addressed in court are also now brought live on live law for each one of you. Hariharan spoke this nonsense. Falana did this. A blow by blow account comes. Now that blow by blow account, essentially what it does, it starts molding the collective conscience of people. Now that collective conscience which gets molded, then post conviction, then they bay for the blood of the concerned accused. The reformative aspect of crime, the reformative aspect which is there in terms of sentencing, takes a back seat. After all, any kind of imprisonment or any kind of punishment has also a reformative angle to it. So what Machi Singh did, Machi Singh spoke about collective conscience. It said that where collective conscience demands a punishment of a severe nature, then death penalty ought to be given. And there were 5 factors at that point of time, which they said in that judgment, that if these 5 criterias are there, then in that case, death penalty is what should be the sentence. And I was in fact surprised. And what was that collective conscience? What was the motive of the crime? What has the motive of the crime got to do with collective conscience? I really can't understand. The manner of commission of the crime, maybe to a certain extent, yes. Whether the person was an antisocial element or not. And what was the magnitude of the crime? See, if there was no magnitude of the crime, there wouldn't be a sentence of this nature. It's you are essentially given a death sentence, you are testing that death sentence on the basis of whether there were mitigating circumstances, because mitigating circumstances were given a complete go-by as far as Machi Singh was concerned. And then, of course, was a very strange circumstance, the 5th one, which said personality of the victim. Now, the personality of the victim in terms of commission of the crime and whether the mitigating circumstances or whether it would be an aggravating circumstance, it's a question which needs to be revisited. So, Machi Singh took away to a great extent what Bachan Singh gave in terms of that balance. Now, post that, there have been further judgments which have come. Of course, these are all aberrations, because even today, it is Bachan Singh which holds the roost, which rules the roost. Because there is a constitutional bench judgment, it prevails. But these are aberrations in the manner in which the aggravating circumstances are being interpreted. I remember there was one judgment which came from the state of Delhi. Now, in relation to that, they said that honor killings, in relation to honor killings, because there were honor killings which happened around that time in Delhi, the sentence which should be given should be death. So, no mitigating circumstances to be looked into. If it is an honor killing, then it should be only a death sentence that should result and nothing more. This was one. There was another judgment which said that in relation to policemen, a custodial death which happens in the custody, when the person is in custody of a policeman, if a custodial death happens there, then death sentence is the only sentence that is to be given. So these were the kind of aberrations which came post Bachan Singh, and these are the kind of aberrations which I feel that sentencing, if we are going to look at sentencing as a corrective philosophy, we need to revisit and further build on those principles of Bachan Singh than go towards principles which have been laid down in Machi Singh and these kind of judgments. Now, having spoken about the death sentence in detail, to a certain detail, there are other judgments also, but I don't want it to go into death sentence alone. I wanted to go into other aspects as well. Now, if we go into the CRPC and the IPC, we have some interesting aspects, because as far as punishments are concerned, there is a chapter in IPC which talks about punishments. If you look into the chapters of the IPC, I think it is chapter 3, most probably, if my memory serves me right. It talks about different kinds of punishments which can be accorded. And amongst the different kinds of punishments, of course, the death penalty and the life imprisonment part I have already spoken about. Apart from this, as punishments, what can be accorded can also be forfeiture of property, it can also be in terms of imposition of fine. So, and of course, as far as imprisonments are concerned, imprisonments to be of two kinds, one of rigorous imprisonment and the other of simple imprisonment. Now, what was the difference between the two? Rigorous imprisonment essentially would mean you have to do hard labor. And simple imprisonment, of course, you can while away your time in prison. Now, talking about these, certain broad provisions I would like to broadly deal with as far as sentencing is concerned. 235 in terms of a sessions trial. 235(2) relates to that aspect which talks about a hearing. It talks about a hearing being given to an accused. That hearing which is being given to an accused is very interesting and very important, because that hearing which is being given to an accused has been now expanded by certain courts to also mean that a kind of a right is inbuilt in the accused to lead evidence in relation to the mitigating aspects as far as sentencing is concerned. There is a judgment by the name of Brigu versus State of UP. I don't remember the citation at the present point of time, drawing on the aggravating and mitigating circumstances which have been spoken about in Machi Singh's case. They have applied this aspect in relation to a normal session trial, because the aggravating and mitigating circumstances otherwise were more or less confined to cases which related to a capital sentence and then thereafter to mitigate that. But this, drawing from that philosophy and drawing from 235(2)'s wording that the accused needs to be heard. So, why is the accused to be heard? Because it is the accused who knows about the condition in which that particular social milieu from which he comes, the kind of psychological setup that was there at the time when the commission of the crime occurred, certain informations which may not be important for conviction, but certainly very important in terms of according a sentence. So this is one aspect which I felt I need to stress upon, because most of us as lawyers do not concentrate on this part. Whereas there are certain advantages on concentrating on this part also. Because if you are able to get hold of a lesser sentence for your accused than the entire sentence which is otherwise there for that particular offense for which he is being convicted, there is a possibility that you may retain the accused in terms of an appeal. If you are able to reduce his sentence in such a way that it is beneath 3 years, he may still persist with you. But if you don't concentrate on that part and the judge goes around to give the entire sentence, I still remember in one of the cases, one of the judges, in a lighter vein, when the final arguments were going to start, when he basically pinned down the counsel for the accused in relation to 2-3 aspects which he was asking. So when the counsel was trying to weave his way through, he tried to bring him back to that by saying this, कि इस aspect पे पूरा बता दो, नहीं तो झोली भर दूंगा. So झोली भर दूंगा there meant that I am going to give you the entire sentence. तो वो झोली भरने का जो कार्यक्रम है, उसको हम अगर we are able to bring it down to a certain extent, tamper it within the period. If there is a minimum sentence prescribed, then of course you are helpless. But if there is a discretion between a minimum sentence and a maximum sentence, if you can bring it down to beneath 3 years, you still have the chance of retaining the client. So that is a kind of thing which a lawyer will be interested in. This is of course a lawyer-centric argument. To concentrate on the sentencing part as well. In fact, in foreign jurisdictions, especially in USA, the moment a trial is about to begin, the legal lawyers team comprises of 2 teams. One which will fight the trial, the other which will prepare itself on the sentencing part as an eventuality, which will gather information in relation to the informations which are personal to the accused concerned, will visit his family, will look into the social milieu where he comes from, look into all those aspects so that that could be used effectively during the course of an argument on sentence. Now this I experienced, because this experience, of course, I was saying that exists in foreign jurisdictions, but interestingly, I had an experience of arguing a death reference in the Supreme Court, where I was ably assisted by Project 39A. That is a very interesting project on death penalty. Now this Project 39A, there was a special team of dedicated lawyers who went and worked on the social and personal and psychological background of the accused concerned. And that was of great help to me when I argued that matter before the Honorable Supreme Court, and the sentence got commuted from death to life. So most of the homework which was done by those young, bright lawyers of 39A, I still remember that as a great experience. So I would urge all of you, when you get cases, you must build those two teams, keeping the interest of, not only if you are representing the complainant, of course, you keep the interest of the victim, but here, keeping the broader interests of the accused. Those two teams will certainly help you a lot, because that is a homework which we do not do. In trial, in fact, I remember situations when a murder case used to happen or any kind of case used to happen, we used to do site visits in our time. We used to go and explore the site, try and see how that incident happened there, which would give us great ideas how to go about the trial when we were indulging in a cross-examination. Now nobody does that. Nobody has the time. So this is somewhat akin to that. So to understand the social background of the person, to understand the social milieu, to understand the personality of the accused and the circumstances in which he committed the crime, you need to do a lot of legwork on that. So you need a team specially dedicated to that, especially in murder cases, if not the normal ones. So going a little further, 235(2) gives that scope. So essentially, once the conviction is done, you need to ask the concerned sessions court that we intend to lead evidence in terms of this aspect. Before you decide on sentencing, we need a personal hearing and evidence needs to be given. In fact, I remember that interesting case where the lawyer argued on the sentencing part, which we normally do. This is a small tip for all of you. And after hearing the lawyer perfunctorily, the normal sentence got passed. It got challenged in the High Court, and the basis of the challenge was the provision said that the accused would be heard. The provision did not say that the defense lawyer would be heard. And the sentence got set aside on this very count. So the hearing, which is envisaged in 235(2), is actually a hearing from the accused. On that basis, you can urge the court that the evidence which is to be led can be led only through the accused in relation to this. And this opportunity will be granted. It is invariably granted in the death sentence cases, which can be extended to normal cases as well. So this was one aspect in relation to 235(2). The other interesting aspect was, there is a very interesting provision 71 in the IPC. Because if you all recollect now, sentencing, why did I choose this sentencing? This sentencing also has been chosen because it is quite in news these days, especially with the Bilkis Banu case. Now that is a moral and a legal question which needs to be answered. There is a challenge before the Supreme Court in relation to that whether the courts were right, whether the question goes from the Supreme Court itself, that whether the Supreme Court to begin with was right in directing the state to consider this case in terms of the old policy. First question. The second question, that whether at that point of time when the plea was made before the Supreme Court, was it brought to the notice of the Supreme Court that this matter essentially was investigated by the CBI. So, when it was investigated by the CBI, the center's consent in relation to that was necessary. Whether this aspect was urged and whether this was considered. And two, what was the composition of the board at the point of time this sentence was considered? Was the composition skewed? So, do we need judicial interpretation, judicial intervention in terms of saying that whenever a situation like this happens, what should be the composition of the board which considers commutation of sentence? So these are certain important issues which will come up and which will be decided in that petition thereafter. So speaking about this in that vein, so I again strayed from that in relation to the fact that Bilkis Banu came to my mind, that sentencing, why sentencing is so important. Now there are two aspects to it. 14 years have gone by. In relation to that, was it enough? Was there a power to commute it? So there are two provisions in the IPC itself. Because once the court passes a judgment of conviction and a sentence thereafter, it is the executive which, in fact, when you look into the provisions, you find that it is executive discretion which is ruling the roost everywhere. If we look into IPC, if I remember correctly, 54 and 55 gives the power to the state in terms of a death sentence to substitute that with any kind of sentence which the state may think of a lesser amount. Complete discretion. 55, it talks about a life sentence which can be substituted by, again, a sentence of a lesser period by the state. So these discretions need to be visited again. And all this will, of course, form a part of the kind of challenge which is coming now in Bilkis Banu. That is why I just thought that I will leave these pointers around as a question to ponder on for all of you. Now, a case like Bilkis Banu, when we look at it from the prism of Bachchan Singh, the balancing of aggravating and mitigating circumstances, and special reasons to see as to why a sentence should be of a greater period. Because this is the Hariharan's case which comes into play here. That all right, your death sentence is commuted to life, but you get no remission for 30 years. Or you get no remission for 25 years. This also the court can do, which did not happen in Bilkis Banu's case. And that is why this commutation happened. So these are all interesting points which I wanted for you to ponder upon and think on. I will end this with one quote which I read, which the famous man Nelson Mandela, who spent 25 years or more in prison, half his life he spent in prison. He said a society is not known by the way it treats its rich citizens. It is more known by the way it treats its lesser citizens. Thank you very much for having come here after an entire day of work and having heard me.